The most powerful court in America has a power the Constitution never gave it. One it simply took for itself, and no one stopped it. 9 justices, black robes, a marble courtroom you're almost never allowed to film inside. It might be the most powerful court on earth. It's also one of the most misunderstood. Most people picture the place where every big legal fight in America gets settled. That's not really what it is. So let's clear it up. How does the Supreme Court actually work? Start with a surprise. The number 9, the 9 justices we take for granted, is not in the Constitution. Article 3, the part of the Constitution that creates the courts, makes one Supreme Court, but it leaves the size, the shape, and most of the court's power up to Congress. When the first Congress set up the court in 1789, it seated 6 justices, not 9, 6. And that number kept changing. As the country grew westward, Congress added seats, 7, then 9, then 10 at the peak during the Civil War. In 1866, Congress actually shrank the court, partly to deny the sitting president any new picks. Then, in 1869, it settled on 9. That's where it stayed for over 150 years. Not because the founders commanded it, just because Congress passed a law, and no one has changed it since. The most famous attempt to change that number came in 1937. President Franklin Roosevelt was frustrated. The court kept throwing out his New Deal programs. So he proposed adding up to 6 new justices, 1 for every sitting justice over the age of 70. Critics called it court packing, stacking the court with your own appointees to change the outcomes. The plan was announced in February. By July it was dead, beaten by his own party. The lesson isn't about who was right. It's structural. The size of the Supreme Court has always been Congress's call. So how does someone actually become a justice? 3 steps. 1. The President nominates a person. 2. The Senate Judiciary Committee, a group of senators who vet the nominee, holds hearings and votes on a recommendation. 3. The full Senate votes to confirm. Today, that takes a simple majority, 51 votes. It wasn't always that simple. For most of modern history, the minority could stall a nominee unless 60 senators agreed to move ahead. That stall has a name, the filibuster, a Senate delay tactic that takes 60 votes to shut down. That changed in 2017. The Senate lowered the bar for Supreme Court picks to a simple majority, a move nicknamed the nuclear option. However you feel about it, the mechanics are the point. Today, 51 votes can seat a justice. And once they're in, they can stay for life. The Constitution says judges serve during good behavior. In plain English, no fixed term, no retirement age, no re-election. A justice leaves only by retiring, resigning, dying, or in theory, impeachment. Impeachment is Congress removing an official for misconduct. It has never actually removed a justice. Their pay can't even be cut while they serve. All of it is designed to shield them from political pressure, so they can rule without worrying about the next election. That's the whole idea. Independence. Now the big question. What does the court actually do? Its core job, to be the final word on what the Constitution and federal law mean. And its single most important power isn't written in the Constitution at all. In 1803, one lawsuit changed everything. It was called Marbury versus Madison. The details are almost boring. A government job was promised, but never delivered. But the head of the court saw a chance. His name was John Marshall. He used this small case to claim a huge new power. Here is what he said. The court can look at any law that Congress passes And if that law breaks the Constitution, the court can cancel it. In his own words, it is the duty of the courts to say what the law is. In plain English, the courts decide what the law really means. This power has a name. It is called judicial review. And here is the twist. The Constitution never gave the court this power. The court simply claimed it, right here, in this case, and it has kept it ever since. But notice the limits. The court doesn't write laws. That's Congress. It doesn't enforce them. That's the president's branch. And it can't just grab a legal question it finds interesting. It can only rule when there's a real fight, real opposing sides, each with a genuine stake. No hypotheticals, no what-if rulings. Lawyers call those advisory opinions, and the court doesn't give them. If there's no actual dispute, the court has nothing to decide. And mostly it isn't running trials with witnesses and juries. It's reviewing decisions lower courts already made. So how does a case even get there? It starts with a request called a writ of certiorari. Basically, please agree to hear me. And here's the thing. The court almost never has to. It chooses. Out of several thousand requests every year, the court agrees to hear only a sliver, well under 2%, somewhere between 60 and 100 cases a term. How do they pick? By an unwritten custom called the Rule of 4. It takes just 4 of the 9 justices agreeing to take a case, not a majority. 4. You won't find that rule in the Constitution, or any law, or even the court's own rulebook. It exists so a minority of justices can force a case onto the schedule, even if the other 5 would rather ignore it. One more wrinkle: state law. If your case is purely about state law, your state's highest court is the end of the road. The U.S. Supreme Court can't touch it. It only steps in when there's a genuine federal question, an issue about federal law or the Constitution. So no, the Supreme Court is not the boss of every court in America. It has a lane. Say your case makes the cut. What happens? First, oral argument. The lawyers stand up and make their case out loud. Officially, each side gets about 30 minutes, though these days it often runs longer, and it's less a speech than a grilling. After a brief opening, the justices jump in with question after question. Then the justices do something the public never sees. They meet in private, no clerks, no staff, no recordings, and take an early vote. This closed-door meeting is called the conference. The Chief Justice speaks first, then each justice in order of seniority. The newest justice speaks last. Whoever's in the majority has to explain why in a written opinion. That opinion becomes precedent, a rule that binds courts across the country. A justice who agrees with the result, but for different reasons, writes a concurring opinion. A justice who disagrees writes a dissent. A dissent decides nothing today, but it can plant a seed for a future court to change its mind. Which brings us to precedent itself. There's a principle called stare decisis, Latin for stand by things decided. The idea: the court should generally follow its own past rulings, so the law stays stable and predictable. But it's a strong habit, not an iron law. The court has said precedent is, in its own words, not an inexorable command. In plain English, not a rule it can never break. When the court becomes convinced an old ruling was badly reasoned, it can overrule itself. The clearest example, 1954, Brown versus Board of Education. A unanimous court held that segregated public schools broke the Constitution's promise of equal protection, equal treatment under the law. And it did that by directly overturning the court's own 1896 ruling, the one that had blessed separate but equal. Same institution, opposite conclusion. That stare decisis bending. The court deciding its earlier self got it wrong. All of this runs on a schedule. The court's year, its term, begins by law on the first Monday in October. Arguments run through the spring, and the biggest decisions, the headline ones, usually land in a rush at the very end of June. So let's pull it together. 9 justices, a number set by Congress, not the Constitution, appointed for life, to keep them independent, wielding one giant power, judicial review, that they handed themselves in 1803, choosing a handful of cases out of thousands, by a rule of 4, bound by precedent until they decide they're not. It's a strange, deliberate design, built to move slowly and answer to the Constitution rather than the crowd. And now you know how it actually works.